Rapper Lil Durk is desperate to get out of jail ahead of his murder for hire case as he stares down a potential life sentence if he's convicted. We have arguments from his defense team for why he should be let out ahead of trial, details from the prosecution on why that is a bad idea, and the ultimate decision from the judge. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. So prosecutors in California say if Durk Banks, known around the world as Lil Durk, is allowed to leave jail ahead of his trial, it will only lead to more trouble. Now, Durk is accused of being involved in a murder for hire plot that left a man dead. And by the way, not the man that Lil Durk allegedly wanted to target. So here's how the story goes. After the death of his friend King Von, Lil Durk reportedly put out a hit on Quando Rondo. This is a rival rapper that he allegedly believed was the instigator behind King Von being killed. And prosecutors say that Durk found out Rondo was going to be in Los Angeles back in 2022, so he allegedly organized a hit. That's it, a hit. Organized members of his crew, a rap collective called Only the Family, or OTF, to travel to Southern California and target Rondo. Now, the government claims that OTF is a criminal enterprise that is engaged in violence, murder, assault. Investigators believe that Durk's right-hand man, a guy named Kevon Grant, is the one who secured the cars, the hotel rooms, and the guns for this assassination of Rondo. And an indictment accused multiple defendants of following Quando Rondo's black Escalade around Los Angeles. In fact, there are traffic camera photos that show a white Infiniti essentially following the SUV until it pulls into a gas station. And the filing also includes surveillance photos of these alleged suspects appearing to fire guns toward the gas pumps, which, by the way, I've said it before, I'll say it again. How this didn't result in just a mass explosion that could have potentially killed so many more is a miracle in and of itself. Hey, so we want to keep on following this Lil Durk story for you. And with that in mind, I have to thank our sponsor, Upside, because it's with their support that helps make episodes like this possible. Now, Upside's awesome. It is a free app that gets you cash back when you buy daily essentials like gas, groceries, food. This is real cash back. It's money that appears in your Upside app that you transfer right into your bank account. Look here. I used Upside to find a gas station near me. I claimed an offer on Upside, pay with my credit card at the pump, follow the steps on the app, and I got cash back. And you can use Upside at all different kinds of places, restaurants, convenience stores. So to find out how much you could earn, click the link in the description to download Upside or scan the QR code on screen. And make sure to use our promo code SIDEBAR because you get an extra 25 cents back on every gallon on your first tank of gas. Now, going back to this case, Quando Rondo, he actually wasn't hurt in the shooting, but it was his cousin, Savannah Robinson, who was killed. Now, Durk has entered a not guilty plea to charges of conspiracy and use of interstate facilities to commit murder for hire resulting in death, and use, carry, and discharge of firearms and a machine gun in furtherance of a crime of violence resulting in death. These are federal charges. And we just learned from a newly unsealed warrant that this is not the only murder for hire plot that Durk might be connected to. During an investigation into the Chicago murder, the shooting death of Stefan Mack outside of a youth center, the FBI discovered that there were several connections between the alleged shooters, Anthony Montgomery Wilson and Preston Powell, and Mr. Banks, Lil Durk. You see, federal agents believe that Durk ordered a hit on Mack as revenge for the death of his older brother, Dante Banks Jr. We actually did an entire Sidebar episode on these new details revealed in the search warrant, so if you want more information, definitely tell you, go check it out on our Law&Crime YouTube page. But to be clear, Lil Durk has not been charged in connection with that Chicago case, but he does face felony charges in this California case. And these are serious charges, serious accusations. I mean, he could potentially spend the rest of his life in prison if he's convicted at trial. But the first legal hurdle for Durk's legal team, which includes celebrity criminal defense attorney Drew Findling, was the application for bail. The ability to try to get out of jail pending trial. And what Durk offered up as far as conditions and collateral, I'll tell you, very similar to what was offered by another music titan facing federal criminal charges, Sean Diddy Combs. I'm going to get to that in a minute. But first, what exactly has to be shown for a judge to deny a person bail? Well, California prosecutors laid it out in their motion to deny Durk pretrial release. So 1, the nature and circumstances of the offense charged, including whether the offense is a crime of violence. 2, the weight of the evidence against the defendant. 3, the defendant's character, physical and mental condition, family and community ties, past conduct, history relating to drug or alcohol abuse, criminal history. And 4, the nature and seriousness of the danger to any person or to the community that would be posed. So really you're looking at danger if he was on the outside, risk of flight, and whether or not this person would actually abide by the conditions of bail. Those are some key categories. And I have to also tell you, prosecutors don't have to prove these kinds of things beyond a reasonable doubt. No, they don't have to prove that he's a danger beyond a reasonable doubt. The standard is much lower. You have to prove by clear and convincing evidence. That is a lower standard than beyond a reasonable doubt. So it's not necessarily as high of a burden to show that Durk could be a danger or something like that. Now, I will say the defense has a different perspective. The defense has argued that Durk is a great candidate for bail, and they listed options to make everyone feel more at ease about letting him out. So in this memorandum in support of Durk's request for pretrial release on conditions, it reads, Mr. Banks, a devoted husband, father, and son, as well as an internationally renowned musician and recording artist, should be granted pretrial release on reasonable conditions that include the following. 1, a bond secured, partially or in full, by $2.3 million in equity in 2 homes in Georgia and $1 million in cash tendered by Sony Music. 2, home detention with electronic monitoring. 3, around-the-clock security services ensuring compliance with all conditions imposed by this court. 4, reporting to pretrial services. And 5, additional third-party sureties and guarantors to satisfy a bond amount that the court determines to be reasonable. So not only would Durk put up the money secured by the value of his properties, but his defense team says that Sony Music is also willing to pony up some money, and there will be guarantors and sureties, there will be security to watch him, and that actually points to the fact that Durk has some serious supporters in his corner, by the way. The defense filed an exhibit that showed good work that Durk has done in his community. Durk apparently started this nonprofit organization called Neighborhood Heroes in 2020. The defense attached a presentation that highlighted what the organization has done the past few years, like food drives, career days, scholarships, fundraising for schools. And the defense did something interesting too. They also pointed out that Lil Durk has previously been charged with a felony, and he was released on bond in that case. In 2019, he was charged with aggravated assault and attempted murder in connection with a shooting outside of a popular Atlanta restaurant. He actually returned early from touring to turn himself in, according to his then lawyers. And in that case, the judge granted him a $250,000 bond. And then in 2022, prosecutors filed a motion saying they were declining to prosecute, and the charges were actually dropped. So the defense's memorandum in this California case reads, Mr. Banks, in that prior case, proved to the court, the prosecution, and the community that he could comply with conditions of pretrial release and court orders. Due to his full compliance with the conditions of release, which originally included a GPS monitor, a curfew, and a prohibition on contact with witnesses, the court gradually expanded and eased the conditions of pretrial release up until the time that the state of Georgia announced their intention to decline to prosecute the matter and asked the court to dismiss the case against Mr. Banks. The best determiner of how an individual will act in the future is how they behaved in the past. And Mr. Banks has shown that he respects the orders of the court and has been an ideal candidate for pretrial release. It's a pretty good argument, right? Now, I will say there are differences, of course, between that Atlanta case and the California case, especially since the older case was in state court while this new case is in federal court. But the argument does make sense. And Durk is saying, I faced charges before, I got bond, I proved I could follow the rules, I should get bond again. The government, as you can imagine, has a different perspective. They say not so fast. Prosecutors filed a brief in support of pretrial detention, saying, this murder case presents a straightforward detention analysis. No condition or combination of conditions can ensure defendant Banks' appearance or protect the community, including vital witnesses in this case. Because defendant cannot rebut the presumption of detention merely by offering a small portion of his wealth in a bond package, he must be detained pending his murder trial, where he faces a mandatory life sentence. Defendant has offered millions of dollars to secure pretrial release, claiming that his money and a private security company hired and controlled by defendant will somehow ensure his compliance with the law and his bond conditions. The proposed terms are woefully inadequate to protect the community and vital witnesses from harm and to mitigate defendant's risk of flight. Indeed, within hours of law enforcement arresting his co-conspirators, defendant was booked on 3 international flights, including at least one destined to a non-extradition country. That is an important point, because you might remember when word got out that Lil Durk was named in connection with this apparent murder-for-hire plot, investigators say he tried to flee the country, or at least that's what the allegation was. There was this affidavit that was filed in support of the indictment, and it read, "The FBI received notifications from U.S. Customs and Border Protection showing that Banks had been booked as a passenger on 2 international flights, a one-way flight from Miami to Dubai, United Arab Emirates, connecting through Doha, Qatar, scheduled to depart the evening of October 24, and a one-way flight from Fort Lauderdale to Switzerland, connecting via New Jersey, also scheduled to depart the evening of October 24th. Banks did not board either flight." And also, not only that, the prosecution claims that Lil Durk rapped about Savannah Robinson's death in a song. Essentially, the argument would be commercializing his alleged revenge. And prosecutors, they also point to the allegations out of Chicago, saying they show a pattern of criminal behavior and interference. In fact, we now know that the prosecution filed an exhibit under seal that accuses Durk of putting out more hits on people. Their brief says, even if the allegations in this case weren't enough to detain defendant, they are. A separate federal case in Chicago also underscores why defendant cannot be released pending this trial. As alleged in a recently unsealed search warrant affidavit in the Northern District of Illinois, defendant offers money for people to kill those responsible for his brother's murder, and more specifically, offering to pay money for any gangster disciple that is killed. Evidence collected in this case also shows defendant has allegedly placed monetary bounties to solicit other murders, including a family member of a witness. Defendant's modus operandi is clear. He will use his power, his money, his influence, and any pretrial release to endanger anyone who he perceives as a threat, including witnesses in this case. And the brief also revealed that Durk hasn't been following the rules in prison. Quote, despite clear instructions to not engage in 3-way calls, defendant has repeatedly abused the phone system at MDC to engage in such conduct. Now, to be clear, that's the MDC out in California, not the MDC in New York, which brings me, of course, back to Sean Diddy Combs, because we've talked about 3-way calls before in connection with Sean Combs' case, his sex trafficking and racketeering case in New York. He's been locked up since September, and prosecutors there said he used 3-way calling to talk to or about people he was forbidden to contact. So Combs would allegedly call someone and then have that person call someone else, creating a 3-way call. And New York prosecutors pointed out there, if he can't follow the rules in jail, how can he be expected to follow the rules outside of jail? In fact, talking about the bail package for Durk, the bail package offered up for Combs to 3 separate judges as his case progressed was also very similar to Durk's. But Combs offered a lot more money, $50 million bond. That would have been secured by the equity in his Miami mansion and his mom's Florida home, too. He would also be subject to house arrest with GPS monitoring. He was willing to hire a security team to make sure he only met and spoke to the people that he was allowed to, which actually makes me think if Lil Durk's offer of a security team was maybe influenced by Diddy's offer, just something to think about. But all in all, it wasn't enough. Judge Arun Subramanian was the 3rd judge to deny Combs' request for bail, and he's currently locked up in the Metropolitan Detention Center out in Brooklyn, New York. Now, what happened in this case? Well, U.S. Magistrate Judge Patricia Donahue of the Central District of California, she made the same decision for Durk. And a new filing shows the government's request for detention was granted. So all in all, Lil Durk will spend Christmas behind bars as his legal team prepares to defend him in federal court. We're going to be monitoring all the updates in this case and bring you any developments as they happen along the way. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.